I call this my coming out of the closet song. I'm not at all ashamed to say that I'm growing marijuana in my yard. Growing marijuana in my yard. Got little pots of pot spread out all over the lot, 'cause I'm growing marijuana in my yard. Well, I got the seed from Mexico. Stuck it in some dirt and let it grow. Put it in my garden with my peppers and my peas, and I get all the smoke I need to breathe. 'Cause I'm growing marijuana in my yard. Growing marijuana in my yard. Keep it where no one can see, so let's keep this between you and me. But I'm growing marijuana in my yard. 'Cause I'm growing marijuana in my yard. I can't tell I'm boss or I'll get hard. I don't grow much, just what I use. Work all day, and when I'm through, I smoke some marijuana from my yard. Now the policeman wants to talk to me. He says, how you gonna smoke up all that weed? He says, money's what you're in it for. Don't you know we're in a war? Now I'm gonna haul your ass down to me. I said, hey man, what is it to you? How do I infringe on what you do? Well, I beg your pardon if you're offended by my garden. But I just can't grow Prozac in my yard. So I grow my own medicine in my yard. I give some to my neighbor for his heart. Shared it with my grandma and keeps it from her son. 'Cause we all know that stuff gets along. Now there's nothing growing in my yard. Those cops to call my lane and both my cars. Now I have to buy my pot from a teenager in the parking lot who's growing marijuana in New York. Oh yeah, I'm growing in their yard. They actually have a yard. Never mind the president, let's overgrow the government and all grow marijuana in our yard. Let's grow some marijuana.
We've talked quite often about how our whole judicial system is just a big criminal enterprise. And we have a good friend, Lydia Radin, who we've done a lot of shows with, and we've been involved in a lot of court cases with Lydia. And the U.S. Marshals private security force actually beat up Lydia to keep her from being involved in a case with Dee Dee Halleck that me and Paula, Lydia, and Dean Radin are all trying to be involved in. And that's been a real problem. And Lydia's taken some real abuse from the court system. So we want to run some stuff by Lydia on Preet Bharara, who is the top guy in what is he again?
What is he?
U.S.
The
top.
United States Attorney General for the Southern District of New York, I believe.
Yeah, I think that's it. Attorney General for the Southern District of New York, and he's been investigating the police for corruption and investigating the police and some politicians for corruption, but he just won't investigate all these corrupt judges that we have. Me and Paula have seen it firsthand when we were dealing with her illegal eviction and illegal rip-off of her apartment down in New York City. We tried to go to the federal grand jury because when you know of a crime, when a judge is committing a crime or a politician is committing a crime, you as a citizen have a right to go before the federal grand jury and make them aware of crimes so they can investigate. Well, we tried on 2 occasions, and Lydia tried to turn in our address and phone number. The U.S. Marshals actually stopped me and Paula on 2 occasions from going up to give our number and our phone number and address so that the grand jury would get in touch with us so we could go before them to point out corruption in the court, that the judges acted in a criminal manner, which should be of no surprise to most people, because most people who've gone before the judges, especially if you go before these judges as a pro se litigant or sur juris litigant, they tend to just ignore anything you're doing and allow the other side, if it's a bar attorney, to walk all over your rights, and the judges actually help them. And so we've had real problems with this. We're still fighting these people, the U.S. Marshals down in New York, and Intercon, which is their security team for the courts down there. So we're attempting to expose, and the only way, since the courts are paying us no attention, the media, our media, that these cameras are some of our best defense. So we want to start this. You can start the thing from Lydia. We'll start that, and then we'll read some more. We want you to listen to this carefully because it points out a lot of the criminality of these judges.
Hello, my name is Lydia Radin, and what you're about to see is a 1 and 45-second videotape that was taken on the 2nd floor of 40 Foley Square. This is a building in Lower Manhattan. The 2nd floor is where the grand jury rooms are, and you're going to watch me knock on a door and hand a yellow piece of paper to the staff person. Looks like a secretary, could be an administrative assistant, and I say to this person, here's another phone number for you. It's the phone number of Joe Barton and Paula Gloria. Joe Barton and Paula Gloria had their home stolen from them in a non-judicial foreclosure. Non-judicial foreclosures are unlawful. They're illegal in New York State. And we checked with Judge Shack before he died, and he also confirmed that non-judicial foreclosures are illegal in New York, as did one of the judges down in landlord-tenant court. Nevertheless, Joe Barton and Paula Gloria's right, constitutionally protected and guaranteed right to due process, was violated when their home was taken from them in a non-judicial foreclosure. So because this is a constitutional violation, they have every right to go down to the federal grand jury, and the U.S. attorney, that would be Preet Bharara, must, not may, but must prosecute for constitutional violations. And this is as per Judge Broderick in the Southern District of New York in a ruling that's called, it's entitled in re grand jury application. No, in the matter of in re grand jury application. The citation is 617 Fed Sup 199, where federal Judge Broderick says there's a group of crime victims in 1985, and they hire a private attorney, and that private attorney makes a petition to the supervising judge of the federal grand jury down in the Southern District of New York. And, he says that these people want to go and present the facts to a federal grand jury because they're crime victims. And the U.S. Attorney's Office is trying to stop them because the U.S. Attorney's Office claims that they're the ones who decide who gets remedy and who doesn't. They're the kings and the queens. They're the Lord King God Emperor and they're going to decide who gets remedy and who doesn't. That's not the way our system works. And Judge Broderick tells them, the first thing he says in this ruling, in the matter of In Re Grand Jury Application 617 Fed Sup 199, the first thing Judge Broderick says is, for constitutional violations, the U.S. Attorney must prosecute, because we don't sometimes obey our Constitution and sometimes we don't. And he also goes on to say, and you can read this ruling for yourself, he also goes on to say that for racketeering, which in my case, for example, would be defined as collection of an illegal debt, Yeshiva University and its medical school, notably Dan Rozelle and Martin Bachstein, executed a fraud on me. They stipulated to Yeshiva University and its medical school, the officials associated with Yeshiva University and its medical school stipulated to fraud and discrimination against me. Those are also hate crimes. So for racketeering, which is defined as collection of an illegal debt, and that would be collecting for classes that were never given to me, and that's for racketeering. The U.S. Attorney Preet Bharara also must, not may, but must prosecute. So this little video that you're going to see is me going down to the federal grand jury at 40 Foley Square last year. That would be February 4th, 2015. I knock on the door. Now, you can see that I'm not trying to gain unauthorized access to the grand jury rooms, because I'm just standing out in the hallway. And it's legal and lawful to film in the corridors, auditoriums, that's the nerve damage that was inflicted on me, unfortunately. In the foyers, so in the auditoriums, in the corridors, and the foyers of federal buildings, it's lawful to photograph for news purposes. So I did so, and I'm not doing anything unlawful or illegal. However, the U.S. Marshal Service, that would be Deputy U.S. Marshal James Howard, does not want me going to the federal grand jury because he knows he's going to be indicted for conspiracy. And that would be conspiracy to commit federal student loan fraud, racketeering, which is collection of an illegal debt, which is the federal student loan fraud in my case. So on February 4th, 2015, I go to 40 Foley Square, second floor, knock on the door, write down my name and phone number, hand it to the support staff, and there's another video that you're going to see where obviously I'm not trying to gain access to the federal grand jury rooms. I'm not trying to storm the grand jury rooms. I'm just standing out in the hall, giving my name and phone number to the staff, saying I'm a crime victim. I'm being subjected to racketeering, hate crimes, constitutional violations, and I'd like to make an appointment to sit down with the federal grand jury as per this ruling with Judge Broderick. Oh, and what Judge Broderick says in this ruling that I already cited to, he admonishes the U.S. Attorney, and what he says is, Judge Broderick is trying to maintain the status quo. So what he says in this ruling, in the matter of In Re Grand Jury Application 617 Fed Sup 199, he says, that's the citation. What he says is that he strongly suggests that the U.S. Attorney should take this attorney who was hired by this group of crime victims, into the grand jury as a witness to present the facts that these people have alleged. So he's trying to maintain the status quo. All right, well, I'm a pro se, and I'm sui juris, pro se, pro per. I'm an educated person who can speak for herself. And the CPLR in New York defines anyone who prosecutes their own case or litigates their own case as an attorney. So I'm an attorney characterized as such by the CPLR. I don't particularly agree with it, but that's what the CPLR says. That would be the Civil Practice Law and Rules. So Preet Bharara, the U.S. Attorney, could take me as an attorney, as I've been characterized, into the federal grand jury as a witness, just like in the same manner that Judge Broderick in 1985 strongly suggested to the U.S. Attorney that he take this private attorney that this group of crime victims hired into the federal grand jury to present the facts. Now, the last thing that the U.S. Marshals in the Southern District of New York want is me going into the grand jury to present the facts, because they'll be indicted for money laundering and conspiracy, fraud, and federal student loan fraud, because Deputy U.S. Marshal James Howard, Deputy U.S. Marshal Jerry Sanseverino in Newark, New Jersey, and Deputy U.S. Marshal Paul Safer out in Trenton, New Jersey, have been conspiring to commit federal student loan fraud, collection of an illegal debt against me and taxpayers. So what you're going to see in this little video, this minute and 45 minutes, is me going up to the federal grand jury for, I don't know, the second or third time on February 4th, 2015. I knock on the door. I give the lady that comes to the door, the secretary, and remember, I'm filming in the corridors where it's lawful to film. It's lawful to photograph for news purposes. And I hand, you can see me hand the secretary, lady, administrator, whoever she is, staff person, I hand her a yellow piece of paper and I say, I have another phone number for you. That's Joe Barton's phone number, Paula Gloria's phone number. They're crime victims. They need to make an appointment to speak to the foreman of the federal grand jury to start an investigation into widespread systemic public corruption in their case. They have had their home taken from them with a non-judicial foreclosure. They need to speak to someone about this, to start an investigation, to criminally prosecute the dishonest judges and attorneys. And the secretary says, yeah, I'll give it to the appropriate people. And I say, well, who are the appropriate people? Oh, we'll give it to the authorities. And I say, well, who are the authorities? And she says, we'll give it to the U.S. Attorney's office. That would be Preet Bharara's office. And I'm like, no, ma'am, you won't, because that's not the proper person that we asked. And the U.S. Attorney's office, that would be Preet Bharara, is not Lord, King, God, Emperor, who decides who gets remedy and who doesn't. So this is, and obviously, AUSA, Assistant U.S. Attorney Stephanie Lake, did not do a thorough investigation, because obviously I'm not trying to gain unauthorized access to the grand jury rooms. I'm just reporting racketeering to the federal grand jury. It's not a crime to report racketeering to the federal grand jury. It's our duty to report racketeering and constitutional violations to the federal grand jury, so that the wrongdoers, in my case, that would be Yeshiva University, its medical school, and officials associated with this racist school. Remember, Yeshiva University and its medical school stipulated to fraud and discrimination. That would be hate crimes against me. So, and also, they violated my constitutionally protected and guaranteed rights. So, for violating my constitutionally protected and guaranteed rights, and for racketeering, U.S. Attorney Preet Bharara should be taking me, Lydia Radin, into the federal grand jury to seek an indictment against the wrongdoers against me, because for constitutional violations, Preet Bharara must, not may, but must prosecute, because we don't sometimes obey a constitution, sometimes we don't. And the same is true for Joe Barton and Paula Gloria. Oh yeah, and by the way, Joe Barton is a decorated war hero. He's a decorated war veteran. So U.S. Attorney Preet Bharara, there was some talk on the street that U.S. Attorney Preet Bharara wanted to run for governor next year. Oh yes, and he's prosecuting he's prosecuting police officers, and he's prosecuting some dishonest politicians. But in his own courthouse, U.S. Attorney Preet Bharara is allowing crimes and corruption to happen. And this is the way U.S. Attorney Preet Bharara will allow someone like Joe Barton, a decorated military veteran, to have his home stolen, without due process of law in a non-judicial foreclosure. So, U.S. Attorney Preet Bharara, if you do run for governor, you just lost the military vote. So what we would expect, U.S. Attorney Preet Bharara, is that you would immediately, without delay, contact Paula Gloria and Joe Barton and prosecute the dishonest attorneys, banksters, and judges who took their home from them in a non-judicial foreclosure, which is illegal in New York State. And in my case, U.S. Attorney Preet Bharara, I would expect that you would immediately take me to the federal grand jury to prosecute the officials associated with Yeshiva University and its medical school. That would be Dan Rizal and Martin Bachstein for federal student loan fraud, collection of an illegal debt, and I want all my money refunded to me and all my records given to me, including my letters of recommendation from Senator Moynihan's office and my letters of recommendation that are on Walter Reed letterhead. So let's go to the videotape. This is 1 minute, 45 seconds, where you can see that the U.S. Marshal Service has lied to AUSA Stephanie Lake because I am not seeking unauthorized access to the grand jury rooms. I am doing my duty and reporting racketeering and constitutional violations to the federal grand jury. The federal grand jury, the members of the federal grand jury, have sworn an oath to diligently investigate all crimes in their district. So I'm doing the right thing here. So let's go to the videotape. Oh, and yes, by the way, there's another little videotape too, where I'm talking, and I'll show that in the next clip, where I'm talking to one of the staff members in the federal grand jury rooms located second floor, 40 Foley Square, and she specifically refers me to Chief Judge Preska, the very same chief judge that's responsible for falsifying records at the Southern District of New York and changing unlawfully my writ of prohibition by changing words and phrases and changing the caption. Chief Judge Loretta Preska is directly responsible for changing my writ of prohibition into a complaint so she can shift the burden of proof, which, by the way, is even more criminality by the former chief judge in the Southern District of New York. And that's also on my Crooked Doctors website. So last time I talked to the NYPD, the New York City Police Department officers, they succinctly phrased this as clean your house, Preet Bharara, before you come to the precinct house to prosecute police officers. Clean your house, Preet Bharara. You've got chief judges committing crimes. That would be Chief Judge Loretta Preska, and in another case of mine, Chief Magistrate Judge Deborah Freeman. Clean your house, Preet Bharara. Oh, and by the way, it's your AUSAs, Stephanie Lake and Michael Ferrara, who are colluding in these crimes. Clean your house, Preet Bharara, before you come to the precinct house to prosecute police officers. That's from a couple of my friends who are 911 first responders. Certainly said it succinctly. So let's go to the videotape. Thank you. When did it smell like orange?
Hi. I have another phone number for you.
I've already forwarded the information.
No, this is another person. Yeah, here. It's Joe Barton and Paula Gloria. That's their cell phone number. They're crime victims. They need to speak with they want to make an appointment and have a face-to-face meeting so they can press criminal charges in their case also.
Okay.
Thank you. Who did you forward it to?
I can't give you that information.
You can't tell me who you forwarded my complaint to? But the foreman of the grand jury will be contacting me, yes?
We'll take care of it.
It's not we'll take care of it. The foreman of the grand jury will be contacted.
We'll contact you, we will take care of it.
Who's we?
This office will take care of it.
We'll take care of what? I need to speak to the grand jury. You're not supposed to be blocking my access to the grand jury.
I'm not blocking your access, I'm giving it to the authorities so the proper procedures can be followed.
What authorities?
The U.S. Attorney's Office.
The U.S. Attorney's Office does not referee whether I get to speak with the federal grand jury or not. You're mistaken, ma'am. That's evasive, ma'am.
Okay, I would like to point out, Lydia Radin, when she was going to Yeshiva University,
My name
was
is
a
Lydia
straight-A
Reedon,
student,
and rated at
and they said Lydia had failing grades. Lydia tried to get her grades from Yeshiva University, and they refused to give it to her. Lydia called Yeshiva 6 times trying to get her grades because she wanted to prove she was going to school to be a doctor. Lydia is a very smart person. We know her personally and know this to be true. And now she's become a fantastic lawyer, which I think is probably more her calling than being a doctor. But anyway, she tried to get her grades to prove that she was discriminated against and kicked out of yeshiva so that Jewish students could become doctors and non-Jewish students wouldn't make the grade. Lydia was also helping other students by mentoring them and helping them to get better grades. So the 6 times that she called to try to get her grades from the school, they filed harassment charges, and she was railroaded and did 1 year in Rikers Island where she got beat up. So Lydia had a case against yeshiva, and all kinds of criminalities were done to keep her from getting her case against yeshiva. What was the other point?
She was supposed to pay for classes.
Oh, that was it, right. And on her student loan thing, they were charging her for classes that she never had. And now, out of her disability check, every month they take out money out of her check for classes that she never took at yeshiva, which is fraudulent. And she wanted to get her records to prove it, which they refused to give it to her. And in one of the court cases, they actually admitted quite a bit of the wrongdoing that they did, but Lydia still got no relief. So Lydia's not just a crazy person talking here. Lydia's very together, and she's stand up and she's fighting them. Now, so the court, she also went to court as a witness for us on the case that she was just given to the grand jury. Me and Paula tried on 2 occasions to go to the grand jury, and the U.S. Marshals stopped us from going. If they told us if we even went up on the floor to give the grand jury person our phone number to contact us, they would have us arrested. Lydia managed to get up there and give our phone number to them, and they never called us back, which they're supposed to do. She said she was going to turn it over to the U.S. Marshals. The U.S. Marshals were the same ones that were keeping us from getting there. And instead of them getting in touch with us to see what our problem was, they sent us, what was it again? A survey, you know. So the U.S. Marshals are not doing what they should be doing. They're supposed to help people who have cases, and if a person has a criminal case, we had judges, 2 different judges, act in a criminal manner and vote and go with Chase against me and Paula, who didn't have the legal note to take Paula's apartment. We asked for them, prove that you have the note, that the claim that you have, and they never could produce it. as the same as a friend of ours, Maggie Borges. The Chase Manhattan Bank has never showed Maggie the note, and they're still trying to take Maggie's apartment. This is all in a criminal manner. We tried to bring it before the grand jury, and we were denied access to the grand jury. Two judges who lacked complete jurisdiction. We went before the first judge in housing court when after they did the non-judicial foreclosure, which is illegal. They didn't take us to court. They just decided we're going to foreclose without any ruling from any judge, and they sold Paula's apartment. Now we challenge the guy who supposedly bought the apartment. We told him if Chase didn't have the note to prove that they had any right to claim ownership of this apartment, what did you buy? And he would never answer that, and he wound up sending us a notice that we were being evicted. So he brought us into court, and we went before the first judge in housing court, who acted in a responsible, legal manner and said, non-judicial foreclosures cannot be heard by this court. This court lacks jurisdiction, right? And she said, and the other side said they objected, and she gave a federal ruling which said that non-judicial foreclosures, she did not have jurisdiction. But she said she would give them 30 days if they wanted to file any paperwork in dispute. Well, they dropped the case, and we thought, that's good, we won. They dropped the case. Then they brought it back into the exact same court before a new judge. Now, the new judge has turned around and said, she's going to hear it. We said, wait a minute, this court lacks jurisdiction, and I read the actual ruling from the higher court that the previous judge had given, and I said, this court lacks jurisdiction. And she said, it has a different index number. Now, index number has nothing to do with jurisdiction. You either have jurisdiction or you don't have jurisdiction. It makes no difference what the index number is. So now we said that this judge was biased, and this judge was acting in a criminal manner, and we got that judge to recuse herself. Then they quick shuffled us without giving us a new date or anything. They shuffled us down to another court with another kangaroo judge, and I went through the same thing with her. It's a non-judicial foreclosure. Non-judicial foreclosures are illegal in New York. This court has no jurisdiction, and I've cited the original case of the first court we were in, and I cited the ruling that judge had made, which was from a higher court, higher than housing court. That judge said, same thing, it has a different index number. Now, index number has nothing to do with jurisdiction. It was a hocus pocus just to keep it moving along, right? Then, along the line, we buried the other side in paperwork, which they didn't answer. They don't answer our paperwork, but they put in their own paperwork. Now, we go through a few back and forths, going to court and then coming back and going back and forth. And then one time, the other side, the lawyers don't show up for the other side. And I say to the judge, if we didn't show up for court and they were here, you would rule as a default against us and they would win. They have not shown up for court. We asked the court clerk to default them. The court clerk refused. So then I went before the judge and said, the court clerk wouldn't default them. I want you to default them. They're not here. Then she said, I'm not going to default them. And it got postponed to another date. Then when we came back on the other date, I filled out paperwork saying I demand that this case, I made a motion for this case to be dismissed because of lack of jurisdiction and the fact that they didn't show up. Well, they didn't show up at this case either, right? So I said to the judge, I want this case. I said to the court clerk, I want this case ruled as a default. She said she would not default it. Then I went, which is her job to default it. That's what they're supposed to do. If we didn't show up, they would have defaulted it for the lawyers on the other side in an instant. Then I went before the judge and said, I want a default because this is the second time that they haven't shown up. And the judge said, I had put in my motion papers asking for it to be dismissed. And she said, well, since they didn't show up, I'll rule on your motions undisputed. Now, when you put in a motion and it's undisputed, and the judge says she's going to rule on an undisputed motion, that means she was supposed to say, yes, Joe, what you're saying, we rule yes for you. We rule for you. And we went away thinking that, okay, we won this round. Paula kept going down for 6 weeks. Paula kept going down to look to see if there was a ruling, and they would not show Paula any of our paperwork. Our file was somehow, the clerk's office didn't have it. The judge's clerk didn't have it. Nobody knew where it was for 6 weeks. Then we get a notice of eviction. And we have the marshals at our door evicting us from from Paula's rightful apartment. This was all every step of the way. It was criminal on the part of Chase, on the part of the lawyers from the other side, on the part of the judges, the two judges who heard cases without jurisdiction, ruled completely biased. So these were criminal judges in housing court. So our option, we tried to go to the federal grand jury because we have judges committing crimes against us. And the U.S. Marshals stopped us from going to the federal grand jury, which is a right of any citizen to take. When you know of a judge or a politician doing criminality, it's not just your right, but it's your duty as a citizen in this country to expose this kind of corruption. So the U.S. Marshals stopped us on 2 occasions, threatened us with arrest, and the other case that Lydia was talking about was the Dee Dee Halleck case, where we're fighting with the city of New York, Manhattan Neighborhood Network, and Time Warner Cable. This is producers fighting against our violations of our rights. And that was the case where the security guards working under the U.S. Marshals beat up Lydia to keep her from putting in paperwork in that court case. They instilled fear in Paula. Paula's afraid to even go into that court now because of Lydia being beat up. Dean Lauren, who's also in that case, being threatened and pushed. And so Paula, who originally put her paperwork in first, she put in a, what was it again? You put in. We put in, a motion to intervene. We put in a motion to intervene for Paula into that case. The judge said he was going to put it into the record, but Paula should have just been put in the record by the clerk as soon as it arrived. It should have gone out. The clerk should have put it right into the record where the judge said he was going to put it in, and then within a short period of time, we did it through the U.S. mail. Within a short period of time, they emailed Paula that they had taken it out. So again, we have judges acting in a fraudulent manner, denying Paula her right to be a party to this case. And Lydia and Dean Lauren were witnesses to this. That we believe that was one of the reasons that they also beat up Lydia Radin. Now they tried to charge Lydia after the security guard beat up Lydia. They tried to charge Lydia with assault on a court officer, on a security guard, which was totally a lie. Dean Lauren was a witness to it. So was Dee Dee Halleck's lawyer, who didn't have the nerve or the backbone to stand up. He jumped in the elevator and escaped the scene rather than be a witness, and won't be a witness. When he was a witness, he won't give any statement that he saw Lydia being assaulted by the security guard. So Lydia has really been through a lot in this, so she has mine and Paula's complete support. And what am I leaving out here, Paula? Anything?
No, I think just go.
Okay, I've covered it. Now, Lydia mailed us some brief statements of issues, emailed us, and I'm going to ask George to read it.
Okay. Brief statement of the issue. Please find attached sworn statements from Ms. Elvia Saravia and Mr. Richmond regarding how the U.S. Marshal Service private contract security guards operating as agents for the U.S. Marshals and Homeland Security officers are used as hitmen for corrupt judges. 2. The big picture. We have found cases in the Southern District and in the Eastern District of New York that fit the following pattern. A federal judge lies to lose a case for a pro se litigant. The pro se litigant sues the federal judge. Then the federal judge lies to have the U.S. Marshals beat up the pro se litigant. In one case, they SWAT teamed the guy. The pro se litigant sues the U.S. Marshals. The federal judges lie to have the case against the U.S. Marshals lost. So you see how the judges use the U.S. Marshals as their private army hitmen. In some cases, Homeland Security officers and private contract security guards, agents of the U.S. Marshals, are used too, as happened to me and Dean. 3. Notwithstanding that a litigant party at bar is a protected person and cannot be attacked during arguments, as happened to Bundy's lawyer, Marcus Mumford. I am told, in addition to this being a maxim of law, that Mr. Mumford can long arm to Utah statutes that state this explicitly, and will try to get those for you. 4. Please feel free to give this to Mr. Mumford, as it supports his defense against criminal charges when he was arguing for his client, Bundy, in court last week, and the U.S. Marshals beat him up. 5. In my case, Jason Berg's case, and in several other cases, we are collecting up the hard evidence to show this pattern. In my case, on January 28, 2016, I was beaten up by a private contract security guard, agent of the U.S. Marshals, while in the process of litigating a motion to intervene as of right with members of my independent media producers union in a federal lawsuit where Time Warner Cable Corporation and the City of New York are my adversaries. 6. Also, Dean was pushed, shoved, and terrorized by agents for the U.S. Marshals, private contract security guards, and Homeland Security officers as he is litigating his claims and helping us on July 7th, 2016. And he protected Eric Richmond from getting jumped on 24th June 2016. after an interaction with Magistrate Freeman, wherein federal prosecutors refused to take Dean's sworn witness statement regarding the January 28, 2016 beatdown of Lydia Radin. Paula Gloria had fear instilled in her. This is the definition of terrorism. She was too afraid to attend oral arguments on May 12, 2016 in Halleck versus City of New York. Paula stood outside the courthouse, afraid that if she went inside, she would be attacked as I was. Elvia Sarivia already filed an affidavit wherein she stated that on July 7, 2016, fear was instilled in her, she was terrorized, as she attended court with me, Dean, and other witnesses on July 7, 2016. 7. The sworn statements of Mr. Richmond and Ms. Saravia are from September 23, 2016. Details. The Deputy U.S. Marshals, Homeland Security officers threatened to arrest Mr. Richmond and Ms. Saravia if they sat at the defense table with me to provide assistance to me in violation of my Sixth Amendment constitutionally protected and guaranteed right to have effective assistance of counsel, which is not defined as a bar-licensed attorney, and in violation of U.S. Supreme Court rulings that say litigants can be assisted by unlicensed laymen during judicial proceedings.
That's the one for you, and all these.
Brotherhood of Trainmen versus Virginia ex rel, Virginia State Bar, 377 U.S. 1 NAACP versus Button, 371 U.S. 415. United Mine Workers of America versus Gibbs, 383 U.S. 715, and Johnson versus Avery, 89 S. CT 747.
Those you want.
Dean was present in the courtroom as a witness to these events. I already gave these to the NAACP, National Association for the Advancement of Colored People. Your friend, Lydia Radin.
That was an email she sent to us on this stuff, on what's going on with her. You want to read these?
Okay, so this is CPLR 105 definitions. A. Applicability. Unless the context requires otherwise, the definitions in this section apply to the civil practice law and rules. B. Action and special proceeding. The word action includes a special proceeding. The words plaintiff and defendant include the petitioner and the respondent. Respectively, in a special proceeding, the words summons and complaint include the notice of petition and the petition, respectively, in a special proceeding. C. Attorney. The word attorney includes a party prosecuting or defending an action in person.
You know, it's noticed there it said the word attorney doesn't say bar attorney. Any person, if you're defending yourself in any court case, you should be considered by the court an attorney. The Supreme Court has ruled, and I wish I had the rulings with me, that the practice of law is a common right. That means any person can practice law. Any person can go into court and argue a case. You don't have to be a bar attorney, but the bar attorneys now have this club. The judges are a bar attorney, the prosecutors are a bar attorney, and all these lawyers stick together, and they don't want the average person coming in and arguing their own case because they all want to make money. Your lawyer makes money, your bar attorney lawyer makes money if he's defending you. The judge gets paid, and the prosecutor or the lawyers for the other side get paid The only one not getting paid in any of this is the person who's being victimized by these sham court proceedings. All right, you want to read this?
All right, so we have a declaration, affidavit of Alvia Saravia for the National Association for the Advancement of Colored People, and for Lydia Maria Radin, and for the public record. I, Alvia Saravia, a living woman of 613 Port Richmond Avenue, Staten Island, New York, 10302, one of the heritage and posterity of the Founding Fathers, we, the people, am of full age and competent and willing to testify, and having personal first-hand knowledge of the facts stated herein, swear to the following under penalty of perjury. 1. On September 23, 2016, I accompanied Ms. Lydia Radin to a so-called proceeding in front of Magistrate Henry Pittman in the federal courthouse located at 500 Pearl Street, New York, New York, 10007. 2. Ms. Lydia Maria Radin is defending against criminal charges unlawfully made against her by Assistant United States Attorneys Stephanie Lake and Michael Ferreira. 3. The U.S. Marshals Shane Doyle, Homeland Security Inspector Justin Green, a white man who refused to identify himself, and a black man who gave his name as Valis, aka Valis, aka Matt, aka Max, aka the brother in the Brooks Brothers suit, threatened to arrest me and Eric Richmond if we sat with Ms. Radin at the defense table at Ms. Radin's invitation to provide assistance to her. 4. Also present was United States Attorneys Michael Bayars, Sharanya Mohan, and an intern, Clinton Agresti. I demand the right to offer proof of all that I have testified to in this affidavit, have each statement accepted or rebutted with factual evidence at a for cause hearing within 21 calendar days of tender of this affidavit, and or upon failure to rebut this affidavit by acquiescence, all parties stipulate to the truth of the facts and statements made herein. Failure to rebut this affidavit will be evidence in the matter noted above that complainants, victims, were injured by loss of rights and by government agents' interference, and that they exceeded their jurisdiction. Signed.
Yeah, now there's one more. That was from the woman from...
And affidavit of Eric Richmond for the National Association for the Advancement of Colored People, and for Lydia Maria Radin, and for the public record. I, Eric Richmond, a living man, receiving mail at 2107 Regent Place, Brooklyn, New York, 11226, with contact phone, I'll omit that.
Yeah.
Am of full age, and am competent and willing to testify, and having personal first-hand knowledge of the facts stated herein, swear to the following under penalty of perjury. 1. On September 23, 2016, I accompanied Miss Lydia Maria Radin to a so-called proceeding in front of Magistrate Henry Pittman in the federal courthouse located at 500 Pearl Street, New York, New York, 10007. 2. Ms. Radin is defending against criminal charges unlawfully made against her by Assistant United States Attorneys Stephanie Lake and Michael Ferreira. 3. Ms. Radin invited me to sit at the defense table with her to provide assistance to her, for I did so. 5. The U.S. Marshals Shane Doyle, Homeland Security Inspector Justin Green, a white man who refused to identify himself, and a black man who refused to give me his name, threatened to arrest me if I continued to sit with Ms. Radin at the defense table to provide assistance to her. 6. I left Ms. Radin's table under duress. When I confronted the unidentified black man about his not having the authority to remove anyone like this, especially in light of the fact that he refused to give his name, he stated that his name as Valise. Also present was United States Attorneys Michael Bayars, Sharanya Mohan, and an intern, Clinton Agristi. I demand the right to offer proof of all that I have testified to in this affidavit. Have each statement accepted or rebutted with factual evidence at a for-cause hearing within 21 calendar days of tender of this affidavit, and or upon failure to rebut this affidavit by acquiescence, all parties stipulate to the truth of the facts and statements made herein. Failure to rebut this affidavit will be evidence in the matter noted above that the complainant and victims were injured by loss of rights and by government agents' interference, and that they exceeded their jurisdiction. Sworn and subscribed.
Now that's just part of it. We have been through this with these U.S. Marshals and Homeland Security, which Paula is on now on the terrorist watch list. So is huh?
Lydia, we haven't gotten ours yet.
I mean, I meant Lydia. Lydia's on the terrorist watch list. So is Jason Berg, probably Dean Lauren, probably Paula, and probably me, because we've all gone up against these same. Lydia got the paperwork which showed that she's on the terrorist watch list. I think Jason Berg also got his paperwork which said he was put on. Yeah, I know he did actually. He was put on the terrorist watch list for the same stuff that we've all done, that Paula has done, that I have done, that a few other people have done. Ann, I can't remember. Paula, what's Ann's last name?
Walensky.
Ann Walensky is probably also on the same terrorist watch list. So there's a bunch of us, and we're going to put in paperwork to say we want to see, paperwork from the U.S. Marshals, from the FBI, and from Homeland Security. We want to see whatever records they have on us. Lydia has done it. Dean has done it. Jason Berg has done it. We just haven't gotten around to it. But more than likely, we're all on the same list of terrorists. And I'm going to be doing a show at some point in time as Osama Joe Barton.